it does feel like the pendulum has shifted a bit. It feels like 23XI and Front Row now have at least a little more.
NASCAR just escalated its fight with 23XI Racing and Front Row Motorsports as their antitrust lawsuit officially entered the federal court system on December 1st, 2025. Michael Jordan and Denny Hamlin are accusing NASCAR of running an illegal monopoly, and NASCAR's latest filing shows they're not backing down. The early court documents reveal sharp language, bold claims, and a battle that could reshape how the entire sport operates. The conflict has been brewing since late 2024, when 23XI Racing and Front Row refused to sign new charter agreements presented by NASCAR. While all 15 chartered teams had been engaged in negotiations for over 2 years, these two stood firm, claiming the revised terms fell significantly short. Unlike the rest, they took the unprecedented step of filing an antitrust lawsuit against NASCAR. To understand the gravity of the case, one must first grasp the significance of NASCAR's charter system. Introduced in 2016, this structure is NASCAR's version of a franchise model. A charter guarantees a team a starting spot in all 38 Cup Series races and provides access to a fixed portion of race purse payouts. However, the charters are revocable and not permanent, and 23XI and Front Row argue this lack of permanence, combined with revenue disparities and exclusivity clauses, gives NASCAR unchecked power over teams. 23XI, co-owned by NBA legend Michael Jordan, veteran driver Denny Hamlin, and Curtis Polk, claims NASCAR's conduct has created a hostile business environment where only a select few thrive. Their co-plaintiff, Front Row Motorsports, which won the 2021 Daytona 500, aligns in this belief. Together, they argue that NASCAR has monopolized the top-tier racing scene through restrictive contracts, excessive control over racetracks, and near-total command of car part suppliers. The courtroom drama took an even sharper turn when internal communications uncovered during the discovery process came to light. These behind-the-scenes emails and messages have been explosive. NASCAR executives, including Commissioner Steve Phelps, were revealed to have called Hall of Fame owner Richard Childress a dinosaur, an idiot, and a stupid redneck. Other messages mocked fans' literacy and disparaged Tony Stewart's SRX series, a rival short-track competition. On the other side, the plaintiffs have their own skeletons exposed. A 23XI executive was found to have said that Jim France, NASCAR's chairman, had to die before favorable charter reforms could happen. Hamlin openly expressed dislike for the France family, and even Jordan, in a moment of jest, quipped that he loses more in a casino than he pays one of his drivers. These incendiary remarks underscore the deeply personal and bitter nature of this legal confrontation. While the tension in court is palpable, the stakes are monumental. If 23XI and Front Row prevail, the repercussions could be transformative. The jury would determine monetary damages, and Judge Kenneth Bell could triple them under federal antitrust statutes. Even more dramatically, Bell could order changes that would upend NASCAR's structure, forcing the France family to sell the series, dismantling the current charter system, mandating permanent charters, or opening tracks to outside competition. NASCAR, however, argues that it has not violated any antitrust laws and that its actions are standard business practices. It points to the increased payouts in the 2025 charter deals and emphasizes that even 23XI and Front Row have participated in every race this season as open teams, albeit at a higher cost and with less revenue. Furthermore, NASCAR highlights that charter values have surged, one reportedly sold for $45 million, and that the sport has seen a 62% revenue increase through its new media deals. From their perspective, this suggests a thriving, competitive ecosystem, not one stifled by monopolistic behavior. Despite these assertions, legal experts say 23XI and Front Row have a solid case. One pivotal pretrial ruling confirmed that premier stock car racing constitutes its own market, meaning NASCAR is effectively the only game in town. This narrows the legal argument in favor of the plaintiffs. They also won a temporary order allowing them to continue racing under the old charter terms. Though this was later overturned, it demonstrated the court's willingness to scrutinize NASCAR's control. Discovery has proven to be a legal minefield. Emails reportedly show NASCAR using charter access and track participation as leverage against teams. Combined with rules that force teams to use only NASCAR-approved parts suppliers and the high cost of operating next-gen cars, 23XI and Front Row argue the system is designed to keep new competitors out. This claim is further supported by NASCAR's exclusivity clauses with tracks. These agreements prevent tracks from hosting races from competing series. If true, such practices could seriously violate U.S. antitrust laws by restricting market access and stifling innovation. As trial proceedings unfold, the courtroom will also see some of the biggest names in motorsports. NASCAR wants titans like Rick Hendrick and Roger Penske to testify, though both have resisted. They filed motions to avoid deposition and have only agreed to limited questioning if required. Their written declarations support NASCAR's charter system, showcasing the unity among non-suing teams. Still, it's noteworthy that even these supporting teams admit the 2025 charter deal doesn't meet all their expectations. Adding another twist, NASCAR has requested that some plaintiffs be excluded from attending the trial, presumably to prevent Jordan and Hamlin from swaying the jury. Judge Bell had yet to rule on the matter by the eve of the trial, but the optics are unmistakable. Jordan, a North Carolina icon and former owner of the Charlotte Hornets, is expected to be front and center, possibly becoming the face of the plaintiff's fight. Hamlin, never shy to speak his mind, fired off a provocative statement ahead of the trial. Our fans have been brainwashed with NASCAR's talking points for decades. Lies are over starting Monday morning. It's time for the truth. It's time for change. This public post captures the sentiment behind the lawsuit: frustration, a demand for transparency, and a desire to reshape the sport's governance. Still, the road ahead is long. Legal analyst Michael McCann and journalist Bob Pockrass agree this trial will not end quickly. Even after Judge Bell's ruling, appeals to the Fourth Circuit are almost certain. The losing side could take the matter all the way to the U.S. Supreme Court. McCann estimates the entire process may stretch 2 years or more, with additional delays tacked on if appeals follow. What 23XI and Front Row seek is not just money, but change. They want permanent charters, open access to alternative parts suppliers, the ability for tracks to host events from competing series, and a fairer revenue-sharing model. Their argument is built not just on financial hardship, but on the principle that NASCAR's current model leaves too little room for innovation and competition. Meanwhile, NASCAR wants to hold the line. If they win decisively, the existing model could be cemented, possibly even expanded, with the France family's grip stronger than ever. A win would also likely lead to the redistribution of 23XY and Front Row's 6 charters, which NASCAR claims have strong interest from outside investors, including private equity firms. In the end, this case may determine not just who races, but how NASCAR operates at its core. The outcome will influence sponsorship dynamics, team ownership models, and even the types of cars on track. For fans, it's about more than just the next checkered flag. It's about the future of the sport. The implications of the case also reach beyond the garage. Sponsors are on edge, unsure how long-term agreements might be affected. Track owners, especially those who may want to explore partnerships with other racing series, are watching to see if the exclusivity restrictions are lifted. Meanwhile, young drivers and up-and-coming teams view this as a make-or-break moment that could shape their futures. Whether this ends in sweeping reform or entrenched tradition, one thing is certain: the legal race is on, and it's moving fast. Stay tuned.